Hi guys, it's Kathy. I hope you're doing well. We're back to McDonald. Oh, my son's playing, so we're gonna have to hear him. My bangs are. I'm growing my bangs out, so they're just long enough to be a pain in the ass right now. All right. I'm just looking through chat. I don't see her. She's not here. Hope everything is going well for CJ right now. I hope she's not in pain. We'll see. We'll see. Kelly got better. Kelly came back. Maiko's yelling at me. Maiko! What do they say? Statistically, out of every 100 people, there's at least one serial killer. I wonder, Fozzie's texting me. All right. Yeah, can you hear him, Beverly? He plays Overwatch. He plays video games. So, he gets loud sometimes. Let's get started on this though. This gets loud sometimes too. Here we go. There's no great big peaks except way at the end. It's only an 11-minute video though.
Record, Your Honor. All right, this will be in KSD 518-905, Candace McDonald versus Michael McDonald. State your appearances.
Russell Collins, bar number 11363, on behalf of plaintiff who is appearing telephonically.
Okay, and in the future, Mr. Collins, we need a notice for each hearing that she's going to be appearing telephonically, otherwise the clerk has no way to know.
Okay.
All right. All right, and you are?
Good morning, Your Honor. My name is Michael McDonald.
All right, this is a status check on the refinance documents and the affidavit from your dad regarding the surrender of the weapons. Do you have the affidavit, sir?
Yeah, Your Honor, my grandpa. It's my grandpa. He's actually out of town. They're actually out for 2 weeks. So my grandma went and got a notarized letter saying that they have.
All right,
it.
and did you provide that to Mr. Collins?
No, I brought it here to court.
All right, if you could show him a copy of it.
We're okay with that, Your Honor.
All right. Okay, and did you receive the refinance documents, counsel?
We did not, Your Honor. We, in giving plaintiff or defendant the benefit of the doubt, we reached out to the lending company, the loandepot.com. We then sent we tried a couple phone calls and to get a response. So we sent an email, and we copied Mr. McDonald on that email, saying that he was ordered to give them authority to talk to us. At that point, he did finally respond and gave them authority to speak with us. And even with that, we received two documents. The only two documents we received was a loan application that was filed, I believe, in October, and then was denied in November. We got a letter that was denied, and those are the only documents that we received. Through some telephone communication with the lending company, we were advised that Mr. McDonald did file again in December, on December 27th, but that due to his debt-to-income ratio, that application was placed on hold. They weren't aware that he had been ordered to pay attorney's fees and medical payment and child support arrears. That those orders that had been in place and were reduced to judgment. We advised them of that, and that's when they said with that, at that debt-to-income ratio, it's not likely that this application can be approved, and definitely not for the amount necessary to pay Candace her community share of the equity.
Your Honor, may I speak to that, please?
Yes.
So I did cooperate with getting all the documents that was requested. I gave them permission. They actually relentlessly called my loan company. They harassed them, kept calling them. I actually have recording. I just got off the phone with them. They said that my refi is a clean refi. They are able to do the refinance, but they need a final number, which is still under appeal because the judge actually ordered, Judge Marquis ordered that I pay her attorney's fees $25,000. They didn't take in consideration the $10,000 Candace took, the half equity in the vehicle, which is almost $7,000, and a couple of
I'm
other
not going
things.
to go back and relitigate those.
So
The final number is,
So the final number is still under appeals, Your Honor. So they're waiting to do the
McDonald?
refi based on that. So yes, Your Honor.
what was the amount of the equity that was ordered?
There wasn't a final number because we were waiting. He was going to do the appraisal. He was going to get an appraisal.
What judge is
from
this?
Has been an
the
appraisal.
company. They haven't done an appraisal on the property, so we don't know. And that's
Is this that short, black-haired magistrate? Magistrate or judge?
why it's difficult to even get the refinance because there hasn't been an appraisal.
There has been honor.
We understand.
Mr. McDonald, it's not your turn.
I apologize.
The Candace entered into a real estate contract. They were going to list the home at 189.9, which would put a little over $112,000, a little more than that in equity. $119,000 in equity. We believe there's $72,000 owed on the home. Based on his loan application, they had the home value at 205,000, which would be even more equity, but we don't know how they're coming up with those numbers.
Your Honor, can I speak?
Right, the final number is the appraisal value of the home, and she gets her share of the equity.
But Your Honor, there's actually a lot of orders that were put in place that weren't considered
Mr. McDonald,
for the amount that's
either you refinance it at the appraised amount, or I'm going to give them the order to have you removed from the house and the house sold. Your excuses for not complying with the court's order to get this house refinanced or to sell it is reaching an end.
Yes, Your Honor.
Now, their information from the refinance company is your debt to income ratio is way too high and is not going to approve. A email on the phone is not good enough. I've told you, bring in the documents.
I just received these documents, Your Honor, and I have proof right here saying that I can do the refi. This approval is really clean, but until the court and our borrower agree to a payout, this loan won't go anywhere. They already want $25,000 in attorney's fees and back child support, things that were only at 65 LTV, and we can't go higher than was it 44.8 DTA. The borrower does have an attorney and doesn't seem to really know what's going on. The opposing attorneys are asking me questions, but I am being as general as possible. The spouse is to be paid XXX and sign a quitclaim deed. We do not know what that amount is. So that they're waiting on the actual amount that's owed to her for them to do the refi, and also pending all these Supreme Court appeals as well.
Take the numbers that have been ordered. Those are the numbers that you owe until the Supreme Court says otherwise. Give that number to the refinance company and get a final answer from them as to whether or not they're going to refi or not.
But Your Honor, we found the final orders for the Supreme
All right.
Court.
Mr. McDonald, I'm not going to listen to one more excuse. I just told you what to do.
Yes, Your Honor.
You've got your order to sell the house. Mr. McDonald.
Your Honor, I will get whatever documentation that you need and cooperate, which I've been trying my best.
We've been trying to get you to do this for months, Mr. McDonald.
and I keep getting these.
You've got a deadline.
Your Honor, I will be able to sell the house.
If you get it refinanced before they sell it, fine. Otherwise, the house, they have authority to list the house for sale. And if you won't sign the proper documentation, I will grant the order giving the clerk the right to sign the documents on your behalf.
Can my motion for stay please be
No.
granted? Depending
Not
on
without you putting up a bond,
bond, Your Honor.
a supersedious bond, to show that you will be able to pay your wife what is owed to her
And
your
her
ex-wife,
attorney's
what
fees?
is owed to her, and the fees that are already ordered by the court. You haven't put up anything, all right?
Your Honor, I've also been looking into getting new counsel as
You've
my
got
man shot himself.
prepare your order.
Listen what she's saying.
And Your Honor, can I ask one more thing, please?
You've got your order, Mr. McDonald. They have a right to list the house. If you won't cooperate, they can do it without you. If you get your refinance approved before the house is sold, then you can go forward with your refinance. That's all they want, is for her to be able to get her share of the equity out of the house.
I understand. I'm
And you're holding her up from being able to go forward on her life because what you are doing is impacting her credit. And that is not fair to her. That's on you.
and
She's got to get her name off that house. It's your responsibility to get her name off that house. You haven't met your responsibility, so now the ball's in their court. Get your refinance before they sell the house.
Your Honor, I'm doing my best to do that. I also ask, can you please tell me why I'm getting supervised visits to my children?
No,
Every step of it.
Your Honor,
not before me today.
can we just address a couple of, he's brought up his motion, and we just want to get it on the record that since July, there's been 9 motions filed, 3 to set aside, 4 to modify, and he just filed a new motion on January 3rd, of this year to motion to stay and all sorts of other relief. We can file an opposition to it, but it's stuff that's been litigated since the beginning of this case, and we're back here again and again and again. Is there anything Your Honor can do? Can we?
I'm sure that when Judge Markey or I see that motion, we will look at it. And if it's just a relitigation of what's already been litigated and already ruled on by this court, yes, there will be attorney's fees awarded in this case. So keep that in mind, Mr. McDonald.
Yes, Your Honor.
One last thing, Your Honor, that we just want to get this on the record because of the appeal. It was something that I should have noticed for a motion that was filed back in October 7th by defendant. A receipt of copy was submitted with that, with alterations. It has my signature, but it's been clearly altered from a receipt of copy that
I think you need to have a meeting with the district attorney's office.
Okay.
Your Honor, may I please ask?
No, Mr. McDonald,
Why I don't?
not
why-
without a proper motion in front of me. No,
I asked for an OST, Your Honor, because of visitation.
and that's been denied.
McDonald's, you're done. Every bag. All right, sir. Every bag, let's go.
The order, Your Honor.
Please, Your Honor, I'm asking for this
McDonald,
relief,
you're done.
just to be able to
Every bag,
speak
let's
and as representing myself.
Every bag.
I have to have an attorney just so you don't speak in court.
Come on.
Like, really?
Go.
I just want to be able to.
On the record, Your Honor. All right, this would be in case D 518905, Candace McDonald versus Michael McDonald. State your appearances for the record.
Russell Collins, bar number 11363, on behalf of the plaintiff who is appearing telephonically.
Don Procope is appearing on behalf of the defendant, bar number 6460. He's present, Your Honor.
All right, and this is a motion for exclusive possession.
That's right,
Just
Your Honor.
as a little bit of history, this case has been going on for some time. We've had numerous hearings on this, both Judge Markey and myself. There was a TPO previously issued against dads in effect until June 28, 2017. Orders where the parties were not to communicate with each other by any means. Dad not to possess any firearms until further order of the court. Marital home was to be listed for sale. Dad was previously ordered to enroll in psychiatric counseling and evaluation to determine whether or not his actions will impair his relationship with the children. Court had also expressed concern about him being a possible danger to the children and questions regarding his mental health state. And he was ordered not to have any telephone contact with the children. Parents were to communicate solely through talking parents. And he was to have supervised visitation only through Donna's house. We've had previous hearings. He provided inadequate evidence of his ability to refinance the home to get mom's name off of the financial responsibility on the home. The court ordered the house to be sold and gave mom the right to list the house, and if he failed to cooperate, gave the clerk the ability to sign any paperwork on his behalf. Dad continued to live in the home, has since been arrested and convicted now, and is serving a 120-day, is it a
180-day sentence.
180-day sentence for the violation of the TPO. All right, and domestic violence. All right.
Okay, and Your Honor, after defendant was incarcerated, my client, she retained a real estate agent, and because of his incarceration, the real estate agent went over with a locksmith and changed the locks because he had previously changed the locks, so Candace had no access to the house. After changing the locks, they went back, and a couple days later, and the locks had been changed back. Had been removed and changed. There was a couple doors that the locks were just completely missing. There was a deadbolt, but the doorknob was actually missing on the back door. And we've submitted some of those pictures with our motion that show those locks missing. And with that, Candace has not been able to re-enter the home. We were informed through Mr. McDonald's stepfather that he had been attempting to get family members to bail his cellmate out so that his cellmate could go live at the home. He was going to create a lease so that we would have to go through eviction processors or do whatever it took to get him out before we could sell the house. And based on that conversation, we subpoenaed all of the phone call records from Mr. McDonald since he's been incarcerated up through the morning of January 17th. And through those phone conversations, we've found out that both Mr. McDonald and his mother have created a scheme to get his brother Alex to live in the house, that they were going to create a lease, forge Mr. McDonald's signature, they discussed, and then have Alex living in the house so that we would have to try and evict him if we wanted to sell. And so that is the impetus behind our motion. We have these phone calls if Your Honor would like to hear them. I have a couple CDs that I can give to counsel and to the court, or we can just play them in open court. There's talk of guns in some of these phone conversations. We know that Mr. McDonald advised
I have to object. I apologize. I was never, nobody, my client nor myself, nobody was given these. We're talking about stuff that's ambush.
I appreciate it. Thank you.
It's basically ambush.
Your Honor, we did mention the phone calls in our motion. We were just recently provided those phone calls. It was after our motion was actually filed. We didn't even know counsel was retained to be able to provide him with any documentation until this morning when we showed up at court today. They've filed no opposition to our motion. Nothing has been filed. And at this point, all we're asking for is for Candace to be granted exclusive possession of the home so that he cannot sign any fraudulent leases, have anybody in the house, so Candace can move forward with the sale of the home. With Mr. McDonald being incarcerated, he doesn't need to live there and will not be prejudiced if Candace is given exclusive possession. It'll just allow her to get anybody else out of the house that's there. We've even notified Mr. McDonald's family through some letters that they are more than willing to come over, inventory all of his belongings, and remove them from the house so that they have all of his stuff, so nothing is taken, and he retains all that stuff when he gets out. He will still retain his equity share of the home. We just want to get it sold, Your Honor. And with regard to the guns, Mr. McDonald provided an affidavit the last time we were in court, signed by what appears to be his grandfather and grandmother, stating that a .45 pistol is in their safe. Through some of these phone conversations and the talk of guns, when my client went into the home, there was a mountain of ammunition. There were over 2,000 rounds of ammunition for a 45 caliber weapon, a 9mm weapon, 22. We know that a 9mm weapon is registered to Mr. McDonald, but we have no idea. There was 12 gauge shotgun shells, but we don't know where those guns are. And so we're asking that those guns also be turned over.
Right. What is his equity share in the home? Do we have any idea?
We believe, based on appraisal that Mr. McDonald received a while back, the home is valued around $200,000. There's, I believe, they owe 72. So there's about 130-something thousand. I believe the listing price, and the real estate agent is here right now. I believe the listing price was going to be around 189. And so that would leave a little over $110,000 to $115,000 in equity.
Okay.
All right, so here's a dilemma. You ordered that the house be placed on the market and the listing agreement would be signed, or the clerk of court would sign it. You did not order that she be allowed in that residence prior to any hearing like this today. So first of all, that's my client's residence, has been my client's residence for a year and a half or more, since she left the residence during the pendency of this divorce, etc. Does not live there, has not lived there, and now we have a problem because by herself, while my client was incarcerated, she goes and enters the residence. And now my client is saying there's things missing. And
Of course he's saying
well,
that.
of course, Judge, but the problem is
Of course he's saying that.
you can believe it or not, but it was done incorrectly.
He doesn't have a good record with this court as to his
Judge?
credibility. He's been caught time and time again in misinformation.
Okay, but here's the thing. Why would you even take the chance?
That's not the issue today. The issue is
exclusive possession.
the issue is the exclusive possession.
But and a lot of what was in the plaintiff's
Issue
argument
is-
was nothing to do with that, except what she found allegedly in this residence that she wasn't even supposed to be in. So we're going to end up it's going to end up to be a problem moving forward, because what's going to happen is
We can resolve this all at the end. Right now, we have a house that's been ordered to be sold.
correct.
She is going to be given exclusive possession of that house because Mr. McDonald will not cooperate.
If you let me finish, Judge, I just want to
And
finish.
the equity is going to be held, his share of the equity is going to be held. So if he causes any problems regarding her being given exclusive possession and getting that house sold, by having someone move in there or do his leases, that money that she's going to have to expend to take care of that is going to come out at his share, and he's going to end up with absolutely zero.
Judge, I wish you would
So-
let me finish. You didn't even let me.
This is not the first hearing we've had on
I
this.
understand. It's the first hearing for
You're
exclusive
not
possession.
completely up to speed on
I read the
this.
entire file, Judge.
All right.
I've read the entire file.
Make
I
your record.
understand that his credibility and his perception
Like I do.
of the court is not good. Okay. All I was trying to say is why would you want to take the chance of creating a shadow of a problem as to entering this house without permission of the court prior to being given permission of the court? Because now you're going to have that exact issue. You have things that are going to be missing. You're going to have things that why not have said what they're saying now, which is give my client's family 2 weeks, 3 weeks to get the house of his property cleaned out and protected before you go and change the locks while my client's incarcerated. That really wasn't a smart move to do in this situation.
And it wasn't a smart move for him to do what he did, so he ended up in jail. He had the ability to have the family go over and inventory that because he knew that wife had been given,
When
plaintiff had
permission
been
to
given the
sell.
right to sell,
Right
to
to sell.
list it, which means they had to have access in order to be able to show the house when he was in jail and wasn't cooperating. So I don't have a problem with them changing the locks.
So you
Now, if the family wants to go over there and get his stuff out, they can get it out. In the meantime, Mom is being given exclusive possession of the home.
Can we have a 2-week hiatus on that until my client can get his
No.
things out? So in other words, she can access, she can take this. That's you're just acting for more litigation and everything else. That's all that's happening.
So,
give us 2 weeks, Judge.
He can have a family member go over with her within the next 3 days, take a videotape of the contents of the house.
It's already gone. Everything, things that she took is already gone. So
Now, that's his allegation. She has no reason to take anything. She is going to be able to sell that house. So don't come in here and be throwing out these allegations that you can't back up, sir. Because his share of that equity is going to be held.
shouldn't all of it be held?
His share of that equity
You're an
is
appeal.
going to be held until the end of the case. So, no, we're not going to hold all of it.
So even though the crux of the appeal is the division of property in this situation,
There is no stay in this matter.
it's an automatic stay.
There's not an automatic.
It's not an automatic stay.
Okay, so
Filed Supreme Court.
All right. So,
there's a
you've
stay
got
right
your
now.
motion for exclusive possession. Dad, you've got 3 days to have your representative work out a time to meet with them to have a videotape done. Your client, if she's not contacted by a family representative to come in and work with her on the videotape, just go in with a videotape,
Stop. Sorry.
and we'll deal with all these issues after the house is sold.
He's my partner.
Oh, he wasn't identified. That's why I didn't know
Okay.
he was on council table.
John Oldline on behalf of the plaintiff, 11430.
So, you've got your motion for exclusive possession granted.
Say 2 weeks. 30 days.
Dad, when you get out of
Oh,
custody,
and Judge,
see a psychiatrist. Get your diagnosis.
we're mixing two things together. I understand, but Judge, we do have an issue with regard to my client has financial obligations of child support, etc. Obviously, he's not employed
We're
at the
not
moment,
dealing with that today.
and I'll file another motion.
Thank you.
What I would like to do, though, Judge, is if it's possible, the motions with regard to lifting supervision and everything else right now are really not right for the court because my client is incarcerated and he's not going to be able to deal with these issues. So anything that my client filed that's set for,
The only thing I have today is the exclusive
right, but we have
possession.
hearings set for the next couple weeks.
Okay,
That-
we'll deal with those as those come up.
I was hoping to just vacate them now, but that's okay.
But we can vacate them now.
No, we'll deal with them as they come up. That's fine. That's it. I'll talk to you soon, okay?
Thank you, sir.
Thank you, Your Honor.
We're off the record, man.
Versus McDonald, D15518990.
I don't know what just happened, but that was crazy. Why is that lawyer not in handcuffs? How can a lawyer just be able to talk to the judge like that?
5D and T16170957T. The plaintiff is present, defendant is not. Counsel, your appearances for the record.
Russell Collins, bar number 11363, on behalf of plaintiff, who is present.
Don Burkowicz is appearing on behalf of the defendant, bar number 6460. He's incarcerated in the city jail, Judge.
All right, this is Dad's motion to suspend child support and for attorney's fees, mom filed an opposition and counter motion for sole legal and sole physical custody. You can, oh, she already had a seat. Everyone can have a seat. Counsel, it's your motion to suspend. What statutory authority do you think I have to suspend
Are we back to Judge Markey?
child support altogether rather than reduce it?
Well, I understand, Judge. I mean, I was asking for the moon and hoping that I could get, I mean, I have had it actually occur in child support enforcement court.
I understand. I just don't think I have authority to
And you
suspend
know what?
it
I'll
wholly
take $100 a month.
based on the circumstances. Now, I believe there's been a change of circumstances greater than 20%. That would require me to modify support. That being said, it would be set at the mandatory minimum, $200.
Right.
$100 for each child.
That
All
would be
right.
fine, Judge.
Okay.
Thank you.
Counsel, as to your opposition and counter, well,
That
as
would
to,
be dated back to the date that I filed my motion,
yes.
please.
And your counter motion, not dated back to the date of incarceration,
No.
but dated back to the
March.
date of your motion.
March 7th, I believe, so he would be covered for March.
Yes. Counsel, as to your counter motion for sole legal and sole physical custody, go ahead.
Yeah, Your Honor, could we address the child support as well?
Sure.
Or the
Tell me why you don't think there's a change of circumstances.
Well, we do believe there's a change in circumstances, but we also believe that, pursuant to the case Sanders v. State, that Michael McDonald can be considered voluntarily unemployed or underemployed due to his domestic violence charge that got him incarcerated in this case. The Sanders case took into account several cases. There are several cases they looked at that said it's incarceration for whatever reason precludes a person from seeking a modification. There were other cases that the court looked
He's
at
in
that said it was
He's in
an issue that the
jail
court
without
could
no
look at,
bail.
and the incarceration is a
Run DMC.
proponent that the court could look at if they chose to modify or not. And then it looks into what the charges are, what they're incarcerated for, and in this case, it's not like he's incarcerated for failure to pay parking tickets or for drug charges. This is an actual domestic violence charge that was done in front of the children that got him incarcerated. And we feel that by reducing his child support on those grounds that it's giving him a benefit for a crime that he committed. We think that the child support should stay as ordered and should continue to accrue, that he will have to pay back when he gets released and can find a job.
And I take that into consideration. I understand your argument. I am going to reduce it and find that there was a change in circumstances. I certainly accept and find totally reasonable that perhaps he created those circumstances, but that it'll be set at the $200 mandatory minimum. Now, certainly child support is modifiable in either direction. So when he was released and he finds new employment, that's a change that we'll make when he becomes employed.
Okay.
So it goes both ways.
Can we at least have it in the order that he has to report
what I'm gonna
every
do-
6 months so that it isn't, the burden isn't
Michael,
placed on
you're
mom.
so
I don't
smart.
think that it's. I don't want him to report every 6 months. What I think is appropriate, and I think Mr. Procopius will acknowledge that when he's released, certainly he'll be looking for a job, that it's not his intention to stay unemployed, and that when his employment changes, when he receives a job, he'll notify plaintiff's counsel in writing, and when he has a pay stub, so probably 2 weeks or 30 days after he has a job and he gets his first pay stub, he'll supply that to counsel for plaintiff. And from there, counsel, you two can try to work out what, you certainly know what the calculation would be. You can try to work it out short of my involvement.
Absolutely, Your Honor.
All right, counsel, as to your motion for sole custody,
Your Honor,
Like I said, Mike's smart.
we were here several months ago it was on defendant's motion to modify, and we included in that motion a request for sole and physical, and at that time that hearing was heard in chambers. An order was issued saying that the court would take under advisement our counter motion, but it was a little unclear if it was just the counter motion for fees and costs for having to oppose the motion, or if it also included sole physical custody. We prepared an order, and there was some issue back and forth, and Your Honor wanted us to exclude the sole custody argument. So that's why we've included it here. We believe there has been a substantial change in circumstances affecting.
tell me what it is.
Plaintiff or defendant has been incarcerated for domestic violence that occurred while the children were in plaintiff's custody and in front of the children. He is currently serving.
And that was subsequent to the final order, custody order in this case?
It was.
After?
Women are crazy.
Okay.
The final custody.
What was the date, the alleged, the date of the domestic violence?
It was on, it was in November on Veterans Day.
November 2016?
Yes.
Okay.
And the final decree was entered in October. I believe it was October 31st, or right around there. is when the final decree was entered. He's currently serving a 180-day sentence, and he also has a hearing coming up on Thursday for multiple additional violations of the protective order, and is looking at potentially another 6 months in jail.
A new case or?
A new case.
Okay.
It's not exactly true, but I'll explain.
What is it on Thursday, Mr. Procopius?
What happened was
He's in custody on one
He did get
DV?
convicted of a DV.
Okay.
He had a suspended sentence.
Okay.
He then there had a violation of a protective order that violated this suspended sentence, which
Okay.
then gave him the 180 days
On the first.
on the first.
Oh,
That's
so
what
he
he's
wasn't
serving.
sent. He was violated on the first. Okay.
Correct. When he went to trial, my understanding is when he went to trial on the violations of the protective order, other things came up, and so it's all part and parcel of one area of time. It's not like he
You
continues to
counsel-
violate.
Right. Okay.
I
Wait.
wasn't, but I went and talked to the city attorney or the public defender
Okay.
in the case, and he
Okay.
explained to me what happened because I couldn't figure out what exactly was going on with regard to that. I don't
But
know.
he has another hearing on Thursday.
I guess
He's
I-
facing additional time.
that I don't know, honestly.
That is, Your Honor, and Candace is actually appearing as a witness on Thursday for those new charges. They are actually new
Snoopy,
charges.
are you doing better today?
And from what a domestic violence advocate has advised Candace is he's looking at additional 6 months for these new violations.
I don't think that hearing was yesterday. I think it was a couple weeks ago.
And we believe pursuant to NRS 125-480K, the fact that he has not only allegations of domestic violence but has been found guilty and is serving a sentence for domestic violence, that it is in the children's best interest for Candace to be awarded sole legal and sole physical custody. We were
sorry, Snoopy.
before Judge Hardcastle on November 29th. At that point, she had advised that she was leaning towards granting that anyways, but we agreed to do a supervised visitation agreement instead. Defendant was unable to comply with the supervised visitation. He was continually late. He harassed the staff at Donna's house. He left a package there for
This
Candace,
isn't
which is-
in their
which is
motion,
also,
Judge.
which is one of the violations that is currently being addressed in his new charges.
Was a package of stuff you
A
left at
package.
Donna's house?
He left at Donna's house for Candace.
What was it?
It was a perfume with a picture of a skull on it that said "Crazy Love," and he instructed my 5-year-old to give it to me at the end of visitation.
All right. Well, Mr. Procopius, hold on. Let me give you an opportunity to discuss this, but let me also give you this first. Is it more appropriate for me to hear this after Thursday?
It probably would be, Judge. And the
Does that
fact,
give us a little? Because look, go ahead.
this is, well, first of all, I think it's a little outside the purview. A counter motion like this, when all I'm bringing is a motion to modify child support on a temporary basis, it kind of goes beyond what a counter motion should really be, in my opinion. I mean, because I got hired to do one specific small job. I didn't get hired to argue a custody case. That being said, at this point, on a temporary, you can only do a temporary
She's
anything, no
not.
matter how you do it today. Believe, in my opinion,
Still
because
in court.
you have to have to change custody. You have to have an evidentiary hearing.
Absolutely.
Okay,
My question
and-
to you is based on these allegations, which I don't have a lot of information on, it seems as though you have a little bit more, but not a lot. Do we wait until after Thursday to see what happens on Thursday because it solidifies some issues?
It's fine. And like I said, on a temporary basis, he can't be really involved in legal custody decisions anyway. So on a temporary basis, I don't know that I would have a problem with a temporary sole legal custody situation. Sole physical custody is not even really a word.
Well, and
Okay,
this
it
is what
would
I
be-
struggle. This is what I struggle with. Just like you're saying, Mom already has primary.
Right.
There's already a bunch of other things. I don't know that, and this court, because there's not really a thing, sole physical custody. You already have primary. That's the most you can get. His visitation is supervised. Has it been suspended at this point, though? Well, because
think it
he's in
matters.
custody, right?
Right.
But
You can suspend it temporarily while he's in custody.
I don't know
and
there's
that
any
may-
reason for me to do so because he's in custody.
And my client could have to bring it back to court to modify things once he comes out of custody. All I get it in the situation is this, Judge. You know what? I do abuse neglect work as well. And I've got people that have mental health problems, have serious domestic violence problems, have serious drug problems, and they still get to see their kids.
Here's my concern, and I've given him and that's why I want to wait till after Thursday. If I've given him the opportunity to do supervised visitation and he cannot do or follow the rules of supervised visitation, and he's violating a protective order and trying to utilize the children to send messages and or gifts to mom,
Right.
and he's not appropriate during supervised visitation, I have no other choice.
Right.
So, what I would like to do is wait until after Thursday, all right? So that I have in front of me what happens at the Thursday hearing, all right? If he's convicted of violating the protective order while at Donna's house, that changes what I'm going to do, all right? And it would be solidify and cut down the issues for me. That being said, mom already has primary physical custody. I think temporarily, because he's in custody, mom needs to have sole legal custody. So I'll grant that in part on a temporary basis. Any visitation, supervised visitation that he has is certainly suspended by virtue of the fact that he's incarcerated. When he is released, he can make a motion to start back supervised visitation. I would certainly take into consideration at that time his ability or inability to conduct himself appropriately pursuant to the rules and the orders of this court during supervised visitation. Anything else, counsel?
Yes, Your Honor. I have a couple letters that Michael has written to the children since being incarcerated. These letters contain very, very inappropriate things that should never be discussed with children. And it's what gives us the greatest concern of why he shouldn't even have supervised visitation, even when he gets out, until he can.
Okay, so I just suspended it. Absolutely, I understand your concerns. When he is released, whenever that is, it sounds like there's new charges pending or new violations pending. He will have to come back to try and reinstate supervised visitation. At that time, I'm telling you, it's likely that the court will hear things that he's sending to the kids, his behavior at Donna's house, any violations at Donna's house. Those would all be relevant.
Thank you
and I think
so
I said to
much.
Mr.
Thank
Procopius,
you.
if he cannot
I get it.
abide by the rules of Donna's house, the court is left with no option. I understand, and I need him to have visitation and contact with his children. His children need that. I want him to have that. However, if it is not safe and he cannot follow the rules and he's in custody for violation of the rules, there's little else I can do. My hands are tied. He's created a situation that forces me to, if all of those things are true, to eliminate supervised visitation because it needs to be safe for everyone. All right, that being said, let's come back. Counsel, that trial set for Thursday. You have no information that at this point that it's going to be continued, but that it's a go on Thursday. But the
I would
court.
think since he's incarcerated, he's going to go.
Okay. So let's set it for 2 weeks. Status check. Counsel, if for any reason it is continued, certainly file stipulation and understanding that the idea was to set the status check after that criminal trial, right? And tell me what date the
Ask
trial.
anything that they're going. I need to not be ambushed in court
Your Honor.
with letters and things that are outside of motions. I mean, I didn't write an opposition because it was based on one thing, incarceration. And then they start bringing up all this other stuff in court. That's not the way it's supposed to work. That's all I'm asking, Judge. I don't want to cast aspersions. I just don't. I think I deserve to not be sideswiped in
I
court.
understand.
Your Honor.
Yes.
Just to address that, if we would have gotten an opposition and replied more than 5 hours before we were supposed to come to court, we would have attached all these letters and everything in our reply to his opposition to our counter motion. But he filed that yesterday.
But that was new evidence.
Okay.
You can't do that in a
Right.
reply.
Listen. If this is how procedurally we will proceed, If he wants to reinstate supervised visitation, he will have to file a motion telling me why it's appropriate. And you're going to file an opposition. Attached to it will be all the documents you would like to raise an argument, all right? And I will make a determination, okay?
Thank you, Your
Because
Honor.
it's a visitation schedule, I don't think that I need to have an
No, I'm overruling the judge on this. We need to know immediately the stuff that he does. We need to know right away.
evidentiary hearing, so I'll be prepared
sure.
to make an order at that motion hearing, all right? Thank you so much.
As far as the status check, Your Honor, can we waive Candace's appearance?
Absolutely. Her appearance is always waived unless I make a specific finding that you need to be here. Because of the allegations of domestic violence in this case, I'll always allow you to appear via telephone, all right? Not here in the courtroom unless that's your preference, all right?
Thank you, Your Honor.
Thank you.
Return is May 18th at 10:15.
Thank you, Your Honor.
Thanks.
Have a great day, counsel.
You too.
Ross.
I thought I heard a little kid.
Good morning.
Good morning, Your Honor.
It's the matter of McDonald versus McDonald, D-15-518905. The parties are present. Counsel, your appearances for the record.
Morning, Your Honor. Alex Cubato, bar number 10592 on behalf of Michael McDonald is present.
Good morning.
Russell
Lawyer
Collins,
number
bar
26.
11363 on behalf of plaintiff. And Your Honor, we're gonna ask that this hearing be closed. There's been a lot of stuff going out on social media and just talking about it. It is
What do you-
blown up.
What do you mean, counsel?
Just almost everything that's happened in this case is now all over social media, on Facebook accounts, on different websites, and just the fact that Candace herself has had to, she's been getting requests and notifications from people she's never even met or heard of before, so she's disabled her Facebook account because of that.
Okay. All right. Counsel, your position?
Yeah, as far as the closed hearing, I'm okay with the closed hearing, especially if there's going to be an evidentiary hearing, but I don't want the case sealed.
Today's not an evidentiary hearing, it's just set for motion hearing. So do you have any objection? You stipulate to the closed hearing? It's up to you.
Just closing this hearing. Yes, Your Honor.
All right. So it sounds like there's a stipulation for a closed hearing. We'll close the hearing today. I'm going to ask everybody in the gallery to step out. Anything else administratively we can take care of?
The only other issue, I guess.
Everybody can have a seat too. I'm sorry. Go ahead.
Is I received a reply, an email from Mr. McDonald at about 8:10 this morning.
Oh, I haven't received a
With a
reply.
copy of the reply indicating that he was still representing himself pro se.
Okay. Ms. Counsel, did Mr. McDonald file that, or did you file that on his behalf?
He filed it, Your Honor. I spoke to him late last night, and I.
Did he file it, or did it just get sent? I didn't get a copy of it yet. You know, sometimes when you file something, it takes about 24 hours for the court to see it.
You faxed it to the department?
No, it was.
What time was it filed?
The copy I got, Your Honor, is not file stamped, and I got
Oh.
it this morning.
Okay.
Client's indicating that it was supposed to be filed through his previous attorney, but it never was, so he filed it yesterday.
A reply? He wrote the motion himself, so I don't. His attorney
His attorney, according to him, his attorney promised to file it on his behalf.
file a reply on his
Yeah.
behalf to a
Yes, Your
motion
Honor.
that he. Okay. Oh, you mean Mr. Luke? Is
That's
that
right.
correct? Oh, okay. All right. Well, I haven't considered it because it was filed so late. I'm going to strike it because it was filed this morning. I still haven't had an opportunity to look at it. I was here late last night reviewing this case, and I didn't see it then. So I don't have time to review it. And counsel and Mr. McDonald were about 30 minutes late for the hearing. So had I known about that, I would have had opportunity. I'm not going to take a break and review it now because I have a calendar with at least 10 other matters on this morning to review it. So everybody have a seat. Mr. Collings, I do have a couple of quick questions.
If I may, Your Honor.
Sure.
My suggestion is, since I have been retained on the case, if you want to pass it for just a week, so that I can review the entire record and so that the reply can be considered by the court. I think that as contentious as this case is, as long as it's going on, I think a full fair hearing should be everything that could be brought before the court, including replies, supplements that I may file, any other exhibits, should come before the court. So if there is a determination that's adverse to my client, at least there's a record.
Right. Counsel, your position as to counsel's request for continuance?
Well, Your Honor, we were here on the 5th, and Mr. McDonald showed up with an attorney he had just retained the night before. They requested a continuance so that he could get up to speed on the record. We were ordered to speak, Mr. Luke and myself, which we did.
You did, wonderful.
And he informed me that he was not going to be going forward with representing my
Okay.
We get a reply that's pro se, and then we show up, and we get another request for a continuance. This is Mr. McDonald's motion we're here on. If we're going to continue, I would suggest that his motion be dismissed. If he wants to refile and he can meet with his attorney and refile, then so be it. If not, I think we need to go forward today.
Counsel, what's your position?
I think that would be a waste of judicial resource, a waste of everybody's time. There's already a pleading on file. There's an opposition, a reply's been filed. This court has not had an opportunity to look at it.
Well, it was filed this morning while I was here in the courtroom waiting for you to get here
I apologize, Your Honor.
and your client.
That being said, he's a pro se litigant. He's trying his best under the circumstances. Now, is there any prejudice to the plaintiff in this matter? No, there is none. She's got the kids.
There is prejudice in the fact that she has to keep coming back to hearings and taking work off. Her employers are getting upset, and we just
I'm okay with a telephonic appearance for just a hearing, Your Honor.
Well, this is what we're going to do. This is Mr. McDonald's motion. He filed it on July 27th. We had a hearing 2 weeks ago in which counsel requested a similar continuance and was again retained the night before, and I granted 2 weeks. If this were the other way around and it was plaintiff's motion, I would grant a continuance for more time. But this is Mr. McDonald's motion. I've already gave him continuance so that his counsel can get up to date. To keep doing this does prejudice the plaintiff, and it prejudices the court. We continue to have the same hearing, and I prepare for the hearing in full based on what I've been provided, and my staff prepares, and we continue again. So we're going to go forward today with the motion hearing. I'm not going to consider the reply that was filed this morning. I've already allowed one continuance of the motion so that Mr. McDonald's counsel could get up to date. I'm happy to move forward today, and that's what we're going to do. Mr. Collings, my question to you was, what is the status of the criminal cases right now?
Right now, I don't believe there's any further criminal case. He's on probation. He's there's a stay away order. He's on an ankle bracelet for I believe a year. He is supposed to.
I love ankle bracelets.
He is supposed to complete numerous domestic violence classes.
Okay.
We believe he was ordered to do 52 DB2 classes. He completed 14 while in jail and has not completed any since.
Since he's been released?
Yes. There was another DB2 counseling that had one requirement that has not been completed. A DB2 intake that has not been completed. And he was ordered to pay $1,585 that has not been paid. And then there was an appointment for a DV level 2 intake that was supposed to occur on September 11th, and it just says no show.
Right. Counsel, do you know anything about those criminal cases? What's the status? Where are we at?
My client could speak to that.
Oh, certainly. Well, Mr. McDonald, why don't you raise your right hand to be sworn?
Do you solemnly swear the testimony you're about to give in this action should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
What's the status of the
He's gonna lie out his.
criminal case?
So, Judge, first of all, I'd like to bring up that there was contradictory orders to your orders that was on a divorce decree that led me to get incarcerated.
What's the disposition where we're at?
Where we're at now, there is 3 violations of protective order. One for when I supposedly called her. Well, she called me from an unknown number. I called her back, and I supposedly called her back. Then she called me saying, "Give me more money. I'll let you talk to the kids." I call her back. She says she's recording. There's also an order on the divorce decree saying that was superseded the TPO that stated that we could have reasonable phone conversations with the kids. So it was contradictory to the TPO. That was one violation which I got 179 days for. The other violation was on Veterans Day on 11/11 when she entrapped me to go to her parents' house, which you can verify on Talking Parents, said to come to my parents' house to pick up the kids for your weekend. I'm not there. I show up to pick up the kids, but she would not follow your order that was said to go do the exchange at the school parking lot. On Veterans Day, the kids did not have school. She would not follow those orders. She said to pick them up at the parents' house. So then I show up there. She's there. She calls the cops on me. I leave
Your
with my
Honor,
daughter.
if I may just ask my client a question, have him answer.
Okay, so
Speed it
current-
along.
Counsel, I'm happy for you to counsel your client to answer my question.
All right, okay.
Okay,
So, how many charges are pending currently?
there's no pending charges.
All
my-
have been-
I'm aware of.
All have been resolved.
There are 2 charges for Veterans Day when I showed up there,
Sure, just-
and the DV. They are currently under appeal. I did not touch her whatsoever, and God knows I didn't touch her.
So they were adjudicated, the 3 cases.
Yes.
You were sentenced.
To the max sentence of 52 domestic violence cases, which I did 14.
Okay. And you appealed all those decisions.
The 2 that I could appeal, I did. The other 2 I took plea deals on because I didn't know my rights.
And did you appeal it to the district court or the Supreme Court?
It's currently in the district court in front of Rob Baer.
Okay.
It's
and
going to be.
When is it going to be adjudicated?
Whether the DV it has merit and me showing up at her parents' house. So the violation.
My question is, what is the status? What do you have a next court date? Have you completed your sentence? Have you done the 52 classes?
Sounds like, Your Honor, that they were adjudicated. He was sentenced, and they're on appeal with the district court all over.
Okay, is it true that you have only completed the 14 classes while you were in custody of the 52 you were
I
sentenced
believe
to?
I completed 16, and I have up to 3 years to complete the rest of them. So I'm waiting on that appeal to complete that because there
Okay.
was not.
When is the next court date in municipal court?
I believe it's coming up next month.
I believe it's October 2nd, Your Honor.
Okay, and you believe that you are in
Waiting on
absolute,
transfers.
you believe you're in absolute compliance with everything required of you in the municipal court?
Yes, Judge.
Okay. All right, counsel, do you believe that to be true?
Other than not completing the requirements and not attending classes, we don't believe that he is in compliance.
Okay, all right, very good. Okay.
Well, that could be determined in evidence.
Sure, no, I understand. I need to know if he's still being monitored, all of that kind of information. That's what I needed more information about that I didn't get in the motion. So, that being said, counsel, I know this is Mr. McDonald's motion. You didn't write it. I understand that. So, today, if there's anything you want to add to his pleadings or any oral argument, I'm happy for you to do that now. And Mr. McDonald, you can have a seat.
So, Your Honor, what my concern is that she currently has sole legal, sole physical custody. Obviously, that's everything. That's short of a terminating his parental rights, which is not called for at this point. He did do time. He was in custody. He has pending cases that are on appeal. That definitely is going to protect her from any problems in the future, because if he does anything, he's going to go to jail, and he knows it. The bigger concern is his kids. Now,
10 months.
it's been 10 months since he's seen them. She has sole legal, sole physical custody. I understood that order was entered because he was incarcerated. He's no longer incarcerated.
Hell
He's
yes,
here now.
security.
That's a change in circumstances enough that it'll affect the welfare of the kids, because they should be able to see their father as much as possible. That's by statute. What parent is willing
So
to...
what's your request? What do you think would be appropriate?
Pending,
Visitation.
I think pending trial, I think as much time...
Trial.
Well, what we're asking for, I know that there's a final decree of divorce entered here. What we're looking for is a motion to modify. And there is grounds, at least. There's no, under Rooney, nothing cumulative.
You would like me to treat his, I just want to be clear, and I'm sorry for interrupting you, counsel, that his motion that he's filed, you'd like me to treat that as a motion to modify custody today?
Yeah, yes, Your Honor, that would be
Okay.
best. Because that's what we're looking to do. There are other issues in that pleading related to property settlement and setting it aside. Another decree of divorce was entered some time ago. I am retained. I'm going to consider whether to let that go or file another pleading that's more appropriate under Amy or some other case law or something. Try to do something. But right now, the most pressing issue is custody. He hasn't seen his kids in 10 months. There's no reason for that right now.
So you request me just to, because his motion asks for many things. You want me to focus today on the custody issue and disregard the other issues?
And I will put something back on file if the court allows me to consider it to address all of the property issues. Right now, custody is most important. He hasn't seen his kids in.
All right. Okay, so we're just going to address, which he doesn't call motion to modify. He calls it something else, but I'm going to treat it then, based on your request today, as a motion to modify.
If you see the body of it, the complaint is that he doesn't have his kids, and
Okay.
so I think it's appropriate. There's more than enough to overcome the Rooney standard. This evidence isn't cumulative. It's relevant. He's out of custody. He's going to school now. I believe he's a law student at UNLV. And he wants to have as much time with his kids as possible. I think they deserve that as well. In order to do that under Wallace, the court has to set an evidentiary hearing just on the custodial issues. If the court does that and I review the matter and it seems like property should be at issue for whatever reason, if the court allows me, I'll supplement his motion.
You, of course, can always file an additional motion, counsel.
So leave it at the
I don't
same
have to
time.
tell you that you can certainly do that at any time. What, counsel, do you believe is the change in circumstance that would require under Rooney the modification and the setting of an evidentiary hearing?
Well, he's free now. He's free. That's a substantial change in circumstances that would affect the children's welfare because the dad's free, and I apologize, Your Honor. Dad is free now.
So
He
dad's
is
been
now.
released from custody.
Been released from custody since June. Hasn't seen his kids since then. That's going to harm the kids. They knew their
Thank
dad.
you so much, Fossey.
They knew their dad very well. They had a good relationship. All of a sudden, he's not there. That's a harm to the children. If he comes back into their lives, I would assume, I would hope, that would relieve some anxiety towards them. There's been no allegations that he's harmed them at all. I understand your position, Your Honor, that domestic violence and such is harm to the children, but my suggestion is that it didn't happen in their face, and nor did it happen to them. That being said, the most important thing is they have no contact with their father.
One of the more recent domestic violence, and I understand your position that Mr. McDonald believes that he was wrongly convicted, that one of the children was being held by Mrs. McDonald when Mr. McDonald pushed Mrs. McDonald in an effort to get the children.
So those allegations should be fleshed out. Whatever happens in the criminal matter, Your Honor, it's on appeal. It may be reversed and remanded for further proceedings. I don't know. Even if there's a judgment of conviction, that doesn't mean that you need to sit on and rely on that. I know that this court, that you, Your Honor, have practiced criminal law extensively. People enter into deals all the time, even though they didn't do it, just because that's the best thing to do. This court can make its own determination as to whether there was domestic violence in the house or not. And under, I believe, the case is Castle v. Simmons, if those matters weren't before the court or considered fleshed out prior, you have the opportunity to do that going forward in another hearing. I think that most importantly, it's for the kids' best interest. Right now, they don't know their father. As far as they know, he disappeared, ran off on them. They need to know that he's present, he's in their lives. So I think an evidentiary hearing is warranted. Both prongs of the Yellow Standard are met. And these issues can all be fleshed out at trial. If at that time it's determined that he shouldn't have custody or should be severely restricted, at least he had his hearing. At least he had his day in court.
Okay, thank you, counsel. I'll give you an opportunity to respond.
Thank you, Your Honor.
After counsel. Counsel, now that counsel has narrowed the scope of Mr. McDonald's motion quite significantly. I think that takes about 98% of the arguments away, and we're not going to deal with those. So I don't want you to waste your time because or waste all of our time because that's counsel's request. So, as to the modification of custody, counsel indicates that Mr. McDonald's release from custody is the change in circumstances under Rooney that would require an evidentiary hearing. Tell me why it wouldn't be a change of circumstances under Rooney.
The reason we would say it wouldn't is when supervised visits were first put in place in November.
And that was November of 2016, just after the evidentiary hearing, correct?
That's correct. The evidentiary
So-
hearing was in August.
At the evidentiary hearing, I gave unsupervised visitation, despite all my findings of domestic violence, and allowed every other weekend. Is that right?
That's
And then in November, Judge Hardcastle, based on things that happened between the trial and November, implemented supervised visitation. All right.
Part of Judge Hardcastle's order was that she didn't feel, based on conversations he said he had with his daughter and with his son, that she didn't feel that he could be a rational person and be with the children without it being supervised.
Well, and
And ordered him to get psychological counseling.
at that November hearing.
Yes.
Now, let's talk about those events that happened between the date of the evidentiary hearing and that November hearing in front of Judge Hardcastle, because I wasn't here, it was Judge Hardcastle. And certainly I've reviewed the record, but for our benefit today, were there two situations that led you to file that motion and for Judge Hardcastle to make those findings?
Well, I believe it was actually his motion that he filed. But there were some issues at daycare where the daycare actually got involved, and he tried to give gifts for Candace to the kids. He tried to do a couple different things that he wasn't supposed to do and was ordered not to do.
Did he violate the TPO by entering Canyon Ridge Church and asking to speak alone with his son in a private room? Did he then ask the church staff to produce his daughter?
He did.
And church staff refused?
Yes.
And when church staff refused, did he leave the premises?
I believe they called the cops, and then he left. And I believe there was also an incident at the daycare.
Okay, and what happened at the daycare?
Am I okay to speak?
Why don't you stand and raise your right hand to be sworn?
Do you solemnly swear the testimony you're about to make in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And what happened at the daycare, ma'am?
During that time that it was ordered for supervised visitations, I was told by the daycare director that Michael, there's a keypad. We had changed the keypad because there had been some issues with my code. And so he tried to use the old code. Couldn't get in, so he followed another parent in after they had punched in the code, entered my daughter's classroom. It was during nap time. He picked up another child that was not our daughter. It actually happens to be the director of the daycare. Her daughter is in the same class as my daughter. Picked her up. The teacher was obviously shaken and was like, "What are you doing? You're not supposed to, that's not your kid." And then he went over and found Malia, picked her up, and was attempting to leave with her. And they began to try to stop him. I had a bad feeling that day, so the daycare was calling me anyway, saying that he was there, and I was obviously scared because I'm like, he has supervised visits. Why is he at the daycare? And he was saying, like, when he had her, he was saying, I have a doctor's appointment for her. You can't stop me. I had called the police. They showed up pretty quickly. And the police came. They looked at the orders. They determined he was not supposed to see her. They asked him to leave. And just as a sidebar, like, my daughter still has trauma over that.
To the extent she's going to start speaking to her daughters.
And I appreciate that, your concern. Tell me So that was the incidents at the daycare.
Yes.
That preceded the November hearing.
Yes.
And then at the November hearing, Judge Hardcastle eliminated those visitations. Is that correct?
That's correct. And
Go
at
ahead.
that time, Your Honor, Judge Hardcastle even mentioned that she was leaning towards suspending visitation altogether, and it was actually our request that supervised visits go forward so that he wouldn't be completely alienated, despite his allegations that that's all our intent is. But even at supervised visitations, he couldn't control himself.
So what happened at Donna's house for supervised visitations?
There was, he tried to pass off gifts to Candace. There was supposed to be no communication between he and Candace.
Will you tell me more about that?
What else?
It was on Christmas Eve. My son came out with a bag because on Christmas they're allowed to have gifts. And he came out and he said, "Mom, Dad gave me something. I don't think I'm supposed to have it, but he said to give it to you."
Objection, Your Honor.
pulled
Since
it
that's
out.
hearsay testimony from a child.
I'm going to strike the words of the child. I'm not going to consider that. But for today's purposes, because I wasn't at the November hearing or the January hearing,
Understood, Your Honor.
and I've reviewed those videos and the transcripts, but I do need to understand a little bit more about what Judge Hardcastle was doing in November and then again in January when she eliminated supervised visitation for Mr. McDonald just before he went into custody. So tell me what was in the bag.
It was a small box that had handwriting on it, which I recognized as Michael's. And when I opened it, it was a box of perfume. And on the front was a skull. And the title said Crazy Love, which obviously scared me because I'm like, why would he? What is he trying to say? You know, it
What
made
did
me.
the writing say?
The writing on the box, the perfume was called Crazy Love. And it was like a skull and it was green. And I'm like, what the heck does that mean? And beyond that, there was another situation where Michael was late, and the Donna's house people said that I could leave because it was within that certain amount of period of time. And so as we were leaving, he showed up and he was yelling, and we're driving past and my kids were in the car, and I'm obviously trying to avoid them not seeing anything else that would be traumatizing to them. But he was throwing his hands up, and then my son's like, "Why is Daddy upset?" And I'm just trying to explain, like, he's
I'm going to strike. I'm going to strike what
Thank
the
you, Your
kids say.
I'm sorry.
No, that's okay. I was just anticipating counsel's request. That's all right.
So those were the main incidences that happened.
At Donna's house.
Beyond that,
Okay.
I think that
That's all I needed about from Donna's house. And I'll give you a second to respond. I just needed to understand more about what happens at Donna's house. The report from Donna's house gives me a rough outline of those events, but I needed to know more. So, counsel, from what I've read and reviewing the hearings, it seems as though those incidents made Donna's house close the case and said that Mr. McDonald and this family were unsuitable for supervised visitation at Donna's house, and Donna's house was unwilling to continue supervised visits.
That's my understanding as well, Your Honor.
All right. Okay. So, and I'm sorry to interrupt you so much. That's just the information that I needed from you guys today. So, anything else you want to tell me, counsel?
Well, just the fact that since that time, there were, and it was included in our opposition, there were letters sent from jail to the kids that, knowing that the kids can't read, they were more directed at Candace, but it was, if the kids could have read, there were instances of saying, "Your mommy got me thrown in jail. Your mama stole from me.
Check to that,
Why
Your
would
Honor.
your
To the
mama
extent
do all
we
this?"
have the letter here.
We do have
do
the
have
letters.
the
They're
letters.
attached to the opposition. So I did review those letters.
I don't know that they're authenticated. Or
No, I don't know that either. Is your client saying that he didn't send these? This isn't his letters to his children from
this
jail?
time, given that he is pending a lot of criminal cases, I'd rather him not answer questions like that may get
Okay.
him into more trouble. Here's what I would, if I may, Your Honor.
Sure.
This is all the more reason to have an evidentiary hearing, because here's what happened. Since the first order granting him custody every other week, it's changed to supervised, and then it's changed to nothing. And what's happened in between? No evidentiary hearing. Under Wallace and under Rivero, to change custody, even if it's just timeshare, when there's a custodial, non-custodial parent, there has to be a trial. so that this doesn't happen, so we don't walk into court, testimony from one party, I don't know what she's talking about. I'd like to depose her first to figure it out. I don't have anything that will allow me to rebut anything that they're saying, aside from my client frantically speaking in my ear. I think an evidentiary hearing is more than warranted based on that. It sounds like they have a lot to say. I want to hear it on the stand so I could cross-examine them.
All
That'd
right.
be great.
Let me allow counsel to continue his argument, then I'll give you an opportunity to respond.
Thank you.
Go ahead, counsel.
And Your Honor, just with the Facebook posts that have been going on and plaintiff's inability or defendant's inability to take accountability for his actions that have resulted in what's
Yes,
happened to
sir.
him. He's still sitting here today, claiming he's never filed anything in this court showing that he's appealing these cases. He's never filed anything to suggest that that's even happened other than him saying it. But he just continues, and our fear is even with supervised visits at this time, without him having completed the domestic violence classes, without having completed a psychological evaluation to show that he is a fit parent, that he's going to go in front of these kids and he's going to start talking about the case. He's going to talk about stuff that just isn't relevant. He's still, and I understand that the court has stricken his reply, but he's still, and I believe it's even in his motion, he's still alleging that Candace's boyfriend is a pedophile, that he's shown it to the court that, and it was proven by Metro, by CPS, and even here in court, that the person he thinks is her boyfriend is somebody completely different. It's a completely different person. And Metro substantiated that. They confirmed by doing a check and with the name check, with social security number, that it is not her boyfriend. He's never been convicted of anything. But he continues down that path. He gets stuck on it, and our fear is that he's going to go in front of the kids and say, oh, this guy's a pedophile, this guy's that your mom did this to me, your mom is the one that's destroying our lives, your mom's doing this. And it's stuff that the kids do not need to hear. And if he can go and get the psychological testing, if he can complete the domestic violence classes and come back and show that he's changed, that he's accepted responsibility for his actions, that he's not going to be a detriment to the kids, then supervised visits at that point, there would be no opposition. And if he can comport himself into the future, that he'll get additional time with the kids. But as of right now, he's unemployed. He's not even showed any effort to become employed.
Wait, counsel says that he's enrolled at UNLV Law School.
Well, we would like to see proof of that as well. I don't know how he would get enrolled in law school when he hasn't graduated. He doesn't have a bachelor degree, and he was in jail for the last 6 months. There's no way he could have completed the process to enroll at UNLV Law School. To us, that just goes to additional lies and deceit that he's willing to go through to try and do whatever he has to take. He's already made that claim that he'll do whatever it takes. He'll continue bringing her back. He'll do whatever. But instead of going out and trying to find a job, instead of trying to better himself, he's traveling the country and showing up at court hearings on a daily basis.
I don't know what you're talking about, counsel.
He's became a member with the Veterans in Politics that show up and sit in on
Object
court
to this,
hearings.
Your Honor. They wanna. This is completely irrelevant. It's prejudicial to my client. It's very well known that organization is, as they state, at war with the family courts. To raise that, I think it's completely inappropriate. Has nothing to do with these proceedings at all.
Well, it does, Your Honor.
It doesn't, actually.
It
Well,
does because
is it relevant because he's not working?
Because he's not working, and he's not even trying to work. He's not trying to do anything to better himself.
Give me your card.
Okay.
Yeah, let me-
Anything else,
He was
counsel?
in Washington D.C. and Florida, and if he's claiming if he's claiming he's broke and destitute and homeless now, how is he traveling the world? Instead of paying his portion of medical care, his portion of daycare cost, his child support. He's not shown any effort to change his past or what he's been throughout this entire case. And with that, Your Honor, we would suggest until he can complete the psychological counseling or complete the DV courses, that we stay status quo and no visitation is allowed at this point.
All right.
Your Honor, whether he's.
And I didn't see what you were showing to counsel.
I showed him his Rebel ID card.
Oh, from law school? Okay.
From school. He's an undergrad at UNLV.
Okay.
Planning on going to law school, taking the LSAT, the whole deal.
Okay.
Again, Your Honor, there's a lot of testimony going on here, a lot of stuff this court's never heard that does effect and point towards what's in the best interest of the children. If they're lying, if they can't prove up the things that they're saying, if they're embellishing, that clearly would go to show the willingness to frustrate his visitation and frustrate his time, and a willingness to harm the child emotionally and developmentally because they want him out of the kids' lives this bad. It's too much right now. He hasn't seen his kids in 10 months. Regardless of what's been happening, I think a mother, in the best interest of their children, would try to arrange for the kids to talk to their father. But she's taking it personal. Whatever's between them is personal. It's rubbing off on the kids. That's a problem. And I think given everything that's been stated here, all the facts that are disputed, not disputed, all I could do is I refute everything because I really don't know the truth of the fact. That's what trial's for. If they have a point, prove it up.
Counsel, you're a little late to the party on this one because it's been going on for a while, certainly. So some of the allegations are not allegations, but facts that I've previously found. Others are the result of convictions in criminal court.
Which this court does not have to take as gospel. You can make your own findings. So his contention is...
The conviction creates a rebuttable presumption under our standards, correct?
Well, sure, but I get to rebut it and bring up all this information and evidence that he's telling me and that he wants very badly to tell the court. I don't want him to right now, but all those things can come out. They can be fleshed out. This court can determine, regardless of what the criminal courts said, whether or not a DV occurred, domestic violence incident occurred. And I think that's important under McDonald or Castle v. Simmons. Even stuff that happened before the last order entered, the findings that you made, can be considered if they weren't fully fleshed out. It's the case law says it very clearly. So what's to hurt an evidentiary hearing? Get everything out, get it on the record, and if it turns out that my client is that bad and he's that big of an animal that supervised visitation or no visitation is appropriate, then so be it. At least he got his day in court, which he doesn't have right now. All he has is a hearing right now. It's a motion hearing.
Counsel, I understand and I understand you're doing your job, that you don't want your client to speak today because there's a criminal case pending. At evidentiary hearing, I'd certainly, I think the plaintiff would certainly want to call him as a witness.
And that's fine because...
So, counsel, when do you think, in 30 days, will he be allowed to speak? Because will the criminal case still be pending?
I don't think so.
When counsel will he, because it's certainly his right not to incriminate himself, and that extends to this court. When would he be free to speak freely about these items? And I know I'm kind of putting you on the spot, but I'm just thinking calendar-wise, if I set an evidentiary hearing based on his request to modify custody, at what point? And I don't want him to have to speak, or you know.
What I
would
would
like to
ask him is ask him about procedural matters as far as the criminal case, where we're at.
Oh, okay. That's what I was trying to get initially, and I
Thank
felt
you,
like I
Sierra.
couldn't get any information.
So is there a
Counsel.
TPO? Is a TPO violation pending in any criminal?
There is
court?
no TPO pending. There's
Was there in the past?
There was as soon as I got out of jail, she applied for TPO. It was seen before hearing.
Was it
last week.
violated?
No, sir. And it was dismissed and brought up that she's
Are
bringing
you
more
are you
allegations.
either pending trial or have been sentenced and are pending the completion of requirements in any criminal court here in Nevada?
Not that I'm aware of. The ones that I have is the appeals that are in process, and then that DV class.
Okay, so let's talk about the appeal. So you're appealing a judgment of conviction, a sentence, right?
Yes, sir.
So what were you sentenced on in that case?
Allegedly pushing her, which there was no evidence to.
All right.
And
And the second one?
the second one was for violation of protective order for going to her parents.
All
when
right,
she
so
said to come.
it sounds like there's a DV and a TPO violation that's pending appeal with the Judicial District Court.
And he hasn't completed the sentence on that? Is he still on ankle bracelet monitoring in that case?
October 6th.
It's gonna be, the ankle bracelet's gonna be removed October 6th, Your Honor.
Okay.
Right now, everything stayed pending the outcome, and
Oh, they've stayed his sentence pending the NCOT?
they
Oh.
always do. As far as I know, they always. I know you've done that all. My understanding is that they stay it pending the outcome of the appeal, and those are fast tracked, I think. So,
Yes, sir.
if we get an evidentiary, I think if it's within 45 to 60 days, I think all of this will be resolved, and I'll at least be able to inform the court.
Well, I need to, if I set an evidentiary hearing, I need to set it out a minimum of 120 days to allow the parties their rights to complete discovery in this case. It sounds as though, counsel, there's a lot of information you still need,
Yes.
and I need to give the plaintiff their opportunity to obtain everything they need to obtain. So it would be a minimum of 120 days so that discovery can happen. In the meantime, the order that was set and stipulated to by Mr. McDonald's counsel in the spring when Mr. McDonald was in custody was to temporarily, based on his custody status, change custody to sole legal and sole physical to mom, based on Mr. McDonald being in custody. It's very difficult to have joint legal custody when somebody is themselves, their
Understood.
liberty is impacted. It's hard to make those decisions. So that was a temporary
Me
order.
too. I hope you do too.
Can we adjust it now that he's out of custody? And there is
Here's
a-
my concerns, and I'm ready to make my decision now. So you can have a seat, counsel, unless there's anything else that you need to say.
If there's any concerns with regard to her safety, a mutual behavior order, or even a blanket no contact order, we'd be okay with. If there's that concern by this court.
That's already in place based on his, I believe it's a 1-year order, and we believe, and even the ankle bracelet, we believe.
There's a stay away order
There's
from
a stay away order.
municipal court. Okay.
Yeah, and we would also like the no contact order to stop the incessant emails that she gets.
Right now, she's getting emails from Mr. McDonald?
On talking parents. And,
Despite the stay away order in municipal court?
yeah, she's got some as recently, when was the last one?
2 days ago.
2 days ago.
But
So is there a stay away order in municipal court?
There's always a no contact order in these
Correct.
courts.
And so I'm surprised that
Well, but-
despite the no contact order, there seems to be contact.
Well, those no contact orders almost always exclude communication concerning the kids. And that's what he's alleging was going on. If they're saying it went beyond the scope of that, again, it requires a trial to prove that out, because if
Well,
they're-
I've seen they attach some of the talking parents
they're
printouts.
unauthenticated, they're not authenticated,
okay.
it's not the best evidence. I'd object to all that. We really just need a trial
All right. Okay. Well, I'm ready to issue my decision.
and a behavior order probably.
Well, we
and-
already have we've had a behavior order for about 2 years. We've had a stay away order for about 2 years. We've had stay away orders from municipal court. We've had TPOs. We've had it all.
Judge, can I speak to that, please?
At this point, no, you can't. Have a seat, please. Sit down. Sit down.
It's been, wow.
10 months without seeing his child, obviously, it's going to cause a lot of aggravation. It's going to cause him to act in ways that he shouldn't act. It happens to every litigant. I'm sure you've seen it here in court before. It doesn't reflect their nature or who they are as a person. Right now, as of now, yes, in the past, there may have been this, that, and the other thing that causes court a lot of concern. I don't think that depriving them of custody altogether is the answer. She's the one that's afraid.
And I think, and counsel has indicated the same. Right? He
And so
said
what-
he didn't want, they didn't want to eliminate him. They wanted him to have supervised visitation.
That's my concern. Supervised is just for that. I know that you're just in court yesterday. Your next trial setting is probably in March or April. He has to do supervised visits and all that time. It's going to harm and destroy his whatever shred of relationship he may have with his kids. Maybe if we could do it a little more, it doesn't have to be overnight, but I would suggest a couple, 3-4 hours on the weekends every Saturday and Sunday in a public place, just so that he can bond with his kids, have a good time with them. And
Hell no.
And they're not in danger or at any harm.
They are, though. They are, because he says they've proven that he says these toxic things to these tiny children. He can't do that, and he doesn't get it.
All right. Counsel.
Your Honor, we would oppose that until he is able to complete his class, complete the psychological counseling, and if he can complete that and show that there is no issue, then we could look at.
He's actually in counseling in our approach.
He completed 14 of his 52. I heard from the beginning.
This is from Nancy Sargent Hunterton, a social worker.
Oh, okay.
He's going through counseling. And
With the social worker?
it's a MALMFT.
Oh, okay. Marriage and family therapist. Okay. Anything else? All right.
I believe so, Your Honor.
Thank you, counsel. I appreciate your arguments today. I'm a bit concerned because the facts, as alleged in Mr. McDonald's motion, just the basic facts are incorrect. It says that they stipulated via to the divorce. It's almost as if Mr. McDonald's discussing a different case in his motion and not his own. And I understand that counsel didn't author that for him, that he did that pro per. But I need to take a moment to address the basic facts in this case and the history of this case so that we are all on the same page, because it seems as though just the procedural facts have been lost somewhere in translation. The parties were married September 8th, 2010, and a complaint for divorce was filed just 5 years later, July 31st, 2015. On June 29th, this court extended the TPO that was issued by the hearing master in this case, and the plaintiff alleged prior to trial at least 10 violations of that TPO. He sent prior to trial an 8-page letter cautioning the plaintiff and making threatening statements regarding her consequences if she didn't give him joint custody, and that he would take drastic steps to get his way. Mr. McDonald's original attorney passed away during the litigation prior to the first trial sitting. The court, sua sponte, with my own minute order, continued the trial 60 days so that Mr. McDonald could obtain new counsel. In fact, he did obtain new counsel and was represented by Mr. Anderson and Mr. Smith at motion hearings prior to the evidentiary hearing, and at the evidentiary hearing and trial that was August 16th, 2016. As I've said before, Mr. Anderson did an extraordinary job for Mr. McDonald at that evidentiary hearing, especially on the show cause issues. The trial court found several incidents of domestic violence that occurred during the parties' relationship, that Mr. McDonald held down after back from her from incident. Her closest to me was the alley for the children. He Candace leaving the to medical treatment. Track her.
And when the officer talked to me, he goes, "You need to go down and get EPO." So that's what I did.
Before you moved to Monon?
Yes.
Before you, did you?
Okay. Other videos are playing fine. This one is not.
Posted to me what the
Look.
You came down like that police officer indicated to you that you could do. You come down after.
But this one is.
the alley
So I'm going to fast forward it.
treatment for the children. The name and the of domestic violence and time was imposed.
So I disconnected my camera, my keyboard, everything, because I thought it was me. And now we're just going to go through the rest of this video just like this. I can't type anything.
Ms. McDonald's continued concerns for her safety and the safety of her children are well founded in the facts already found by this court and Mr. McDonald's continued behavior in this case. He has time and again demonstrated his inability to abide by the terms of the district court's TPO, behavior order, stay away order. He has time and again demonstrated his inability to follow the orders of the municipal court. Based on his behavior at Donna's house, and Judge Hardcastle changed his parenting time, his visitation time, to supervised time at Donna's house, which is the court's program that allows for supervised visitation by a third party. Mr. McDonald was unable to behave himself and abide by the rules at Donna's house. The allegation by Donna's house and by the plaintiff is that Mr. McDonald gave a gift to the couple's children, and the child gave that gift to mom, which is consistent with testimony we had at the trial of Mr. McDonald alleging that he gave the children he didn't break into mom's car, that he gave the children gifts to give to their mother for Valentine's Day. So it's very consistent with that gift-giving behavior that we've heard about before. And that the gift was perfume with a skull and crossbones on it called Crazy Love. The name and graphic are not lost. Their significance is not lost on the court. Counsel and Ms. McDonald have been, despite all of those things, rather reasonable in their request. Their request today is that Mr. McDonald not be denied his parenting time, that he just at least finish his domestic violence counseling, that he get the psychological evaluation that Judge Hardcastle ordered in November that we have yet to see. Judge Hardcastle was concerned by his behavior in court, his inability to answer questions, his focus on things, his inability to understand what's going on or what the historical facts are in this case, which I think some of that is set forth in his motion that he filed with the court and can be seen there. I have done absolutely everything that I can do to ensure the safety of Ms. McDonald and the minor children in this case. I have made every order, behavior order, stay away order, TPO extended. I created a visitation plan that gave Mr. McDonald more time with his children than perhaps he deserved, based on his behavior and the things he certainly admitted to during trial, so that these parties wouldn't see each other at exchanges. I'm at my wit's end. Donna's house is inappropriate for this family. Mr. McDonald cannot abide by, he was given that opportunity, it lasted a month, maybe two, to abide by the rules at Donna's house before Donna's house made a determination that they could not supervise this family. I've attempted every conceivable manner and method to communicate with Mr. McDonald.
Thank you, Chaos.
I've yelled at him.
You.
I've spoken quietly and listened patiently. I have begged him and pleaded with him for the safety of those people involved. His behavior continues to spiral. In early spring, based on prior ruling, the court any filed a motion to that custody should resume without evidentiary hearing. And what I will do in this case, because I remain extraordinarily concerned. I was concerned at the very first hearing, the very first case management conference, became very clear to me. Mr. McDonald, and I've said this before, his behavior since the first hearing has increased in intensity, his need for power and control over Ms. McDonald, these children, this court, increases in intensity and frequency. The allegation is that even while in custody, he was writing letters to his children who cannot read. It's difficult for me to understand what I need to do in this case, but I am at this point. I have no more resources. I have no more orders. There's nothing else that I can do to ensure the safety of these parties, the safety of counsel.
Judge, can I stop?
I am going to grant counsel's request for an evidentiary hearing in this case.
Thank you, Your Honor.
But I caution the parties. The evidence that you create, Mr. McDonald, Mrs. McDonald, between now and then, is the evidence I will hear. That hearing will not be, and I will not consider plaintiff's request that if he finishes domestic violence or if he gets his psych eval, then the court will instate reinstate any visitation or create visitation. This is a motion to modify custody. The change in circumstances, he's out of custody. That's the change in circumstances. That's what we're moving forward with. I am concerned because, as I've told you, I don't have a lot of resources. I don't have a lot of safe places for visitation to happen. He can't follow the rules at Donna's house. He hasn't showed me that he has changed, that he is able to, while he's out of custody, and that's a change in circumstance, and now he's certainly available for visitation, because of the extraordinary domestic violence in this case. Because of the threats and my concern of child abduction in this case. I cannot allow, and I don't have a place to send these parties for temporary visitation. I am concerned, and so, based on that, the temporary order will stand with a few changes. I will not allow any communication via talking parents anymore. I am incorporating the stay away order from municipal court. Stay away means stay away. It means as follows, and I have said this, Mr. Collins, probably 5 or 6 times in this case, but let me say it again. It means you cannot be in the same place. You cannot go to her residence, cannot go to her place of employment, cannot go to her place of worship, cannot go to the children's school. You cannot email her. You cannot send her a letter. You cannot send the children a letter. You cannot send them an email, a text message, no Facebook, no MySpace. I don't think people really do that anymore. No social media of any kind. No Snapchat, no videos, no nothing. No carrier pigeon, no smoke signals, no contact. No contact means no contact, means no contact. This might be the 8th time I've said that in this case. Today, if there are any questions about what no contact me now, so that there's no parents.
Your Honor.
All right. I'm hopeful that I've said it in terms that are very simple, that everybody, counsel, if you think that I am unclear about something or you have a question in your mind about that, will you ask me now so that I can clarify it?
I fully understand what the court's goal is, and I will explain it to him thoroughly. No third party contact, no contact via any form of communication. I've done many TPOs and I've been in these courts a lot. I can explain it to him, Your Honor.
Thank you, counsel, and I rely upon you to answer any questions that he might have. And I think I can rely on you to do that, certainly, counsel, and I take you at your word. If there is an issue or you think that there's some confusion or that I've perhaps explained that in a way that he didn't understand, that you will take the time to make sure that he does understand that today.
I appreciate this court's ruling, very happy about it. What I would suggest is, the visitation is so restricted, it's so limited, and you've indicated that everybody wants this guy to prove that he can be a father. He's interested in it. The only way to do that is to actually give him time with his kids. I know Donna's house is given to the boot. It's not the first time they did it. Do it to a lot of my clients, actually. Unfortunately, you can reinstate that, Your Honor.
Not willing to do it right now, and here's why. The nature of the violation to me was so egregious. And is consistent with past behavior in this case with gift giving. The nature of the orders were so explicit. It was so close in time to a hearing in this case where he just lost his weekend visits and Judge Hardcastle gave him the supervised visits, and it was so close in time to that it's very concerning to me.
I totally understand the concerns the court has, and you obviously want to err on the side of caution. But that being said, again, those were allegations made after the decree of divorce. There's no trial where any of that was proven up, it's easy to get up here and make this, that, and the other statement. All the other side can say, I lied. Or
Counsel,
that didn't happen.
Makeup visitation may be appropriate.
I appreciate
If we find out that
Hi, guys.
mom has concocted this story and that there was no perfume bottle and that this perfume bottle with the skull and crossbones wasn't given, certainly it's not for these little children, wasn't given to the children, then I would absolutely entertain your request for makeup visitation. At this moment in time, I feel as though, and I've tried to be extraordinarily transparent so that counsel, you understand what I'm thinking and where I'm at, that I just have no more resources, no more options. There's nothing else or no order I can make that's going to stick or work, or that I think at this point Mr. McDonald will understand and abide by.
And I appreciate that, Your Honor. What I would suggest then, and I appreciate indulging my argument, once these cases are resolved one way or the other, if I can put a motion back on counter, on Chambers counter, just to review and reevaluate after the criminal matters are all resolved. Maybe he's acquitted, and maybe he takes a state adjudication, maybe it's something less than what it is now. Maybe based on that, the court would be more willing to open the door, if I could just have that opportunity to do that.
So you have every opportunity to file a motion in this case whenever you'd like. I'm not going to limit or prohibit when you file a motion. I'll tell you that
Concern is attorney's fees and sanctions, obviously.
well, I don't think you're telling me that you would do it now when the criminal case is ended, and it sounds like he has a lot more classes to do, so it's not going to end between now and our trial date. His criminal case is going to be ongoing. There's one domestic violence class per week, and he still owes, the vast majority of those classes. So, and counsel's indicated that if he finished those classes and he had a psych eval like was previously ordered almost a year ago, that they would be willing to talk about visitation. And so you might not even need me at that point. But I think certainly counsel has set the mark on what they're looking for.
I appreciate that. Thank you. As far as the mental health eval, I know that Community Center, Las Vegas Community Mental Health, does it on a sliding scale or fairly cheaply. Because the other doctors, Paglini, Blinkai, it's $3,000, $4,000, $5,000 and up for that kind of thing. So.
I'm not going to. That was Judge Hardcastle's order. She didn't order a specific psychologist or psychiatrist, but a psych evaluation certainly needs to be done by a psychiatrist, at a minimum a psychologist. A family therapist is not going to be able to diagnose or do the evaluation that Judge Hardcastle had in mind based on Mr. McDonald's behavior. Unless, counsel, you had another...
That's exactly what we were thinking.
Since he's not doing the classes and all of that he's supposed to do, the psych eval, she should make him do community service hours at like a mom's house. One of the women's batterers' houses. However, she can't do that because he'll probably just pick up his next girlfriend there. And that's scary.
Your Honor.
Okay. So, and you can certainly, and then once we have that report, we'll consider it, and certainly, counsel might want to see the doctor and do some cross, and I leave that to counsel. I think that will get there. I'm going to set a full day in the ordinary course. My temporary orders will stand with the inclusion of the absolutely no contact, including talking parents. I'm going to order that plaintiff's counsel print off the PDF from talking parents and close the account. Counsel, you have an opportunity to print the PDF version of the talking parents as well. Why don't you close that out in 1 week from today? So you have 1 week from today to download that PDF, counsel, should you think that you need it. But I just don't want to leave that gateway between the parties open. Although I've ordered no contact, I can't be assured that that will be followed. So at this point, I'd like to just to close that communication opportunity 1 week from today. I'm going to issue a scheduling order. The scheduling order will be issued this afternoon. And counsel, are you retained in this matter? Can I send it to you, or are you unbundled today?
I'm retained as of now. I may file a motion to withdraw sometime later, but if you send it to me, I'll make sure that my client gets it and understands it.
Right, my order today will then be to you, counsel, that I'm going to issue this scheduling order this afternoon. It'll be e-filed into the case, and you'll both have electronic service of it. If either of you withdraw from this case, short of evidentiary hearing, my order is that you turn that document over to your clients so that your clients understand when the witness list has to be done, when the pretrial memo has to be done, and all the other deadlines that we contemplate and counsel is well aware of, but your clients might not be, when we contemplate evidentiary hearing, right? Issues of attorney's fees will be deferred, counsel, to the evidentiary hearing, and we'll deal with those at evidentiary hearing. I will set full day and calendar call now, and then I will give you your scheduling order this afternoon, right?
Friday, March 16th at 9 o'clock.
Did I say that again?
Friday, March 16th at 9 a.m.
She just said
Calendar
10
call.
o'clock. Now she said 9.
March 8th, 10 a.m.
Thank you, Your Honor.
Thank you.
I'm
Want
drafting
me to
it.
prepare the order?
I'll draft it.
All right, I want you to spell out two things, counsel, that I'm looking for. The stay away order, and that violation of the stay away order would lead to contempt time between today, this moment, and evidentiary hearing until further order of the court, and that no longer will the parties be able to
Plot
communicate via
twist.
talking parents.
I'll
Right.
include that.
Thank you so much.
Can you clarify that as well for 179 days?
McDonald versus McDonald, D15-518-905D and R17-199-625R. Parties are present. Counsel, your
Different
appearances
lawyer.
for the record.
Russell Collins, bar number 11363, on behalf of plaintiff Candace McDonald, who is present.
Yeah, Robert Luke, bar 1489, on behalf of Michael McDonald, who's present.
Good morning, Mr. Luke. Everybody
you-
have a seat. Go ahead.
Yeah, no, I just wanted to advise the court, I'd left a courtesy call this morning. Mr. McDonald just retained me like late Friday afternoon.
Okay.
And obviously, before a 3-day weekend, I have not had time to, review the file. I know it's extensive. I know there's a TPO case and a misdemeanor violations of the TPO municipal court and all that. But I was going to be requesting the court today for about a 3-week continuance so that I can assemble the file, get the materials together. I want to be able, in the context of this case, to be able to make appropriate representations to the court on factual and legal matters.
I appreciate that, Mr. Luke. Counsel, do you have any objection to his request for 3 weeks?
I don't have a problem. We do have some concerns about some activities that have been taking place over the last couple of weeks, and even as recent as Sunday.
Okay, well, can we find a date in 3 weeks and everybody have a seat? And then what's going on right now? Maybe Mr. Luke can be of assistance to you in that way.
My client received some phone calls from the children's school and the children's daycare that they've been receiving phone calls from Mr. McDonald, inquiring about the children. wanting
Objection,
records,
hearsay.
wanting different things. She's been receiving calls from bill collectors saying that they're getting her phone number from Mr. McDonald. She got one as recently as this morning.
Okay.
There's also, she had a friend call her from on Sunday, said that Mr. McDonald was there at her church and was following her around to the point where she had to actually go talk to security. And he was actually told by security he had to stay there until she actually left.
Mrs. McDonald's friend.
Her friend, yes.
Okay.
And this is that's a church that Miss McDonald has attended in the past a couple times. With the kids, it's our belief that he was probably there, hoping that she would be there with the kids, but we don't know that for sure.
Okay.
And there's just issues like that are ongoing. Some of his messages on talking parents have been inappropriate, and so we just
In what regard, counsel?
just threatening to her to her new boyfriend.
Threatening in what way?
Just threatening with constant legal action if she doesn't comply and let him see the kids. Requesting or just blaming her for everything that's happened to him, that she's conspired with myself to get him thrown in jail, that he's not taking accountability for any of his own actions, and he's constantly blaming Candace. He's written it in letters to the kids. And it's just disturbing that this is ongoing after so much has happened in this case, that he just hasn't seemed to learn or take responsibility or take accountability for anything that's happened. And it's concerning to Candace that he's going to show up, get the kids, and take off with them.
Counsel, I'm hopeful that this is something you talked to Mr. Luke about in the interim. And I think Mr. Luke, I appreciate your addition to this case, Mr. Luke, and perhaps you could speak with your client and try to resolve some of these issues. They weren't in the motion. I'm not going to make an order about them, but counsel, you know that that type of report is disturbing to me, and I'm hopeful that we can move past some of these things and work together. Mr. Luke, I want you to get caught up on the case. It's a lot to ask right now since it's been pending for a while. And perhaps you and counsel could speak. I am going to order you two to speak in the next 48 hours and try to resolve some of these issues.
I could try, but by the time I assemble stuff, it's going to take me more than 48 hours.
I just want you to understand what his concerns are right now, his immediate concerns.
Yes.
I don't expect you to respond, but I want you to understand what they are so that you can speak with Mr. McDonald about those immediate concerns.
Right. No, that's why I wanted time to check it out, because accusations are easy. Proof is not always easy.
Well, the talking parents transcript is certainly available to you at any time.
Yeah, that's what I'm saying. I want to see what's objective and what's not. I mean, going to the school, he's the father. If there are school records, he has a legal right of access to school records. So there are things like that I'm going to check out and whatnot. If there are issues here, then I will speak candidly with my client and
I appreciate
do my best to work them out. And
let's look at the 3-week calendar.
Yeah.
3-week days?
Just a minute. Just a minute.
It's your 27th and August 27th at 8:45.
August.
I'm sorry, September. Look at me. I apologize, counsel.
September 22nd.
27th.
At 9:30?
8:45.
8:45.
Does that work, Mr. Luke?
Yes.
Counsel, does that work for you?
That works for me.
All right, I'll see you then.
And my client says he hasn't seen his children in 9 months, and I think the only thing I could request at this time would be some supervised visits at Donna's
The
house.
request is denied.
Thank you.
McDonald versus McDonald. McDonald versus McDonald. D.
Shit. Okay. So the one I just skipped is this 22nd one right here. We're going to see that. Don't worry. The one that we just watched was September 5th. The one before that was September 27th. So it was after the one that we just watched. So I don't know how that makes sense, because he had this lawyer here and here, right?
Bryce McDonald, D15-51890.
Maybe he didn't. And then he has this other lawyer, and then it doesn't matter. I'm going to play this 20-second video, and then that'll be good for today, even though there's way more. Darn it. Why can't we just... Oh, if I had a quarter jar for every time I swore, America doesn't have that much money. Just doesn't. Here we go.
Is this way?
Goodbye.
Oh, look at her.
You can go off.
Tase him. Ooh. Oh, man. Yeah, he was walking right toward her, looking right at her. Okay. Maybe. Yep. All right. It's time for OJ. I didn't get it set up, so I'll start a new one. Thank you so much for coming out, guys. That was wild and crazy. Whew. Thank you so much. I hope I see you soon without any glitches. Oh no, I gotta start OJ and I disconnected my keyboard and everything. I'm gonna need a minute before I start OJ. Play it again. Just hold on. Did someone ask me to play it again? Chat goes too fast. Yeah, play that again, please.
Is this way?
Goodbye.
Okay. Maybe he wasn't.
Is this way?
Goodbye.
Shut up, Fozzie.
You can go off the record.
Oh. I'll fix it tomorrow. He's a jerk. He's a jerk. Alright, guys, I'm gonna hook my keyboard up, then start OJ. Alright? Thanks a lot, guys. I'll see you soon. Bye.
Got this life that goes digital dreams through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no